So today we will be discussing the kinds of conditional obligations. First off, we have suspensive condition or the condition precedent. You have to read Article 1187 and Article 1188. So these articles refer to suspensive conditions. So what do we mean by bring the appropriate actions? According to JBL Reyes, the phrase may bring the appropriate actions is inaccurate. To bring action is to file a suit, but the creditor is not restricted to filing a suit. So the proper verb is not bring but take. For example, in a sale of land, subject to suspensive condition, the creditor should have the suspensive condition annotated on the title of the land. This is not bringing an appropriate action but taking an appropriate action. The principle in this article is the laws aid those who are vigilant, not those who sleep upon their rights. So the question is, why does Article 1188 give the creditor a recourse, although technically the creditor still has no right? So the answer is because as a matter of fact, although technically the creditor still have no right, he is already expecting a right. You cannot let the creditor sit and fold his arms and wait for his right of expectancy to be rendered illusory. So you also need to read Article 1189. So when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. Number 1, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. Number 2, if the thing is lost through the fault of the debtor, he shall be obliged to pay damages, and it is understood that the thing is lost when it perishes or goes out of commerce or disappears in such a way that its existence is unknown or it cannot be recovered. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment with the indemnity for damages in either case. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. And if it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. So let's go to resolutory condition or the condition subsequent. Article 1190 refers to resolutory conditions. This is just the opposite of Article 1189. So you have to read 1190 for resolutory condition. So a condition is a future and uncertain event upon which an obligation or provision is made to depend. Futurity and uncertainty must concur as characteristics of the event. And a past thing can never be a condition. A condition is always future and uncertain. How about past event unknown to the parties? So it is really the knowledge of the event which constitutes the future. It is the knowledge which is future and uncertain. For example, I will treat you for lunch if you get the highest score in civil law final exams, on the assumption that our professor has already finished checking the papers. Here, the event, which is getting the highest score, is already a past event, yet the knowledge is future and uncertain. So let us now compare a condition to a term. So conditions can either be suspensive condition or the condition precedent, wherein the happening of the event gives birth to an obligation. On the other hand, a resolutory condition, which is the condition subsequent, wherein the happening of the event will extinguish the obligation. So magkabaliktad yung suspensive and resolutory condition. Because in suspensive condition, yung happening of the event gives birth to an obligation. On the other hand, sa resolutory condition, the happening of the event will extinguish the obligation. So comparing condition to a term or period, you have to read Article 1180. So when the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. So dito, sa 1180, si debtor nag-promise siya na magbayad pag meron na siyang pera. This obligation shall be deemed to be one with a period. Why? Kailan ba yan? Kailan ka ba magkakapera? Kaya hindi natin alam. A term is a future and uncertain event upon which the demandability or extinguishment of an obligation depends. So, the period must be future, certain, and possible. Sabi natin kanina, hindi natin alam kung kailan ka magkakapera. Pero for sure, alam ko, magkakapera ka in the future. Hindi nga lang natin alam kung kailan. That is why that is considered as an obligation with a period. Again, period must be future, certain, and possible. Kailangan masuffice itong tatlong requirements na to. Yung futurity, certainty, and possibility. So, a term can either be suspensive term, or one the arrival of which will make the obligation demandable, or resolutory term, or one the arrival of which will extinguish the obligation. So, the period after which the performance must terminate. So, terms classified according to source. We have legal, which is period fixed by law, voluntary, stipulated by the parties, and judicial, which is fixed or allowed by courts. May also be expressed or those specified, and tacit, which is stipulate. Example given is stipulated to do some work which may only be done at a particular season, or an original period. Number 2, grace period extension fixed by parties, or it may also be definite, fixed known date or time, or indefinite event will happen but not known when. So what is the effect of a period? An obligation with a term is demandable only when the day fixed for performance arrives. So the right of action arises only when the date fixed arrives. So Article 1193, you have to read that. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. So obligations with a resolutory period take effect at once but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. So, a term or period as an interval is an interval of time which exerting an influence on an obligation as a consequence of a juridical act either suspends its demandability or produces its extinguishment. In a suspensive term, the obligation has already arisen except that it is not yet demandable. You also have to read Article 1194. So for Article 1195, anything paid or delivered before the arrival of the period, the obligor being unaware of the period or believing that the obligation has become due and demandable may be recovered with the fruits and interest. So 1195 applies only to obligations to give. How about mistaken or premature delivery? This article assumes two things. The delivery was by mistake, or the mistake was discovered before the term arrives. Both the things and the fruits can be recovered. If the term has already arrived, the question is moot and academic. But can he recover the fruits produced during the meantime? It depends on what school of thought you follow. According to Professor Tolentino, according to one school of thought, the debtor is entitled to the fruits produced in the meantime. However, according to Attorney Kagiwa, according to another school of thought, all the fruits received during the pendency of the term belong to the creditor. So, presumed for whose benefit? Sa kanilang dalawa. Article 1196 provides that whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances, it should appear that the period has been established in favor of one or of the other. As a general rule, if a period is attached in an obligation, the presumption is that it is for the benefit of both parties. The consequence is that the creditor cannot compel the performance before the arrival of the term, and the debtor cannot compel acceptance before the arrival of the term. If the term is for the benefit of the creditor, the creditor can demand performance anytime, but the debtor cannot insist on payment before the period. Again, if the term is for the benefit of the creditor can demand performance anytime, but the debtor cannot insist on payment before the period. On the other hand, if the term is for the benefit of the debtor, the creditor cannot demand performance anytime, but the debtor can insist on payment. The debtor can insist on performance anytime. Example, I promise to pay within 60 days. So this is a term for the benefit of the debtor. I promise to pay Clara the sum of 100,000 pesos on or before October 31, 1996. This is a term for the benefit also of the debtor. In a contract of loan without interest, the term is usually for the benefit of the debtor. Thus, he may pay in advance. If there is a stipulation as to the interest, period is generally for both parties. The debtor cannot pay in advance versus will of the creditor unless he also pays in full. So how about when no period is fixed? So these are the cases where the courts may fix a period. You have to read Article 1197, Paragraph 1. And Article 1197 states that if the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that the period was intended, that the courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. Katulad nung sinabi natin kanina, na I will pay you pag nagkaroon na ako ng pera. Yung magkakaroon siya ng pera, alam nating darating yun, pero hindi natin alam kung kailan. And this is where the courts, this is when the courts shall also fix the duration of the period stated by the debtor. Kasi sabi dito, the courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the courts shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be exchanged by them. This is the general rule. However, there are exceptions. One of the exceptions is Article 1682. Article 1682 states that the lease of a piece of rural land, when its duration has not been fixed, is understood to have been made for all the time necessary for the gathering of the fruits, which the whole estate leased may yield in 1 year, or which it may yield once, although 2 or more years may have to elapse for the purpose. Article 1687. If the period for the lease has not been fixed, it is understood to be from year to year if the rent agreed upon is annual, from month to month if it is monthly, from week to week if the rent is weekly, and from day to day if the rent is to be paid daily. Article 1606. In pacto de retrosale, where the period is not specified by the parties. The right referred to in Article 1601, the right of conventional redemption, on the part of the vendor a retro, in the absence of an express agreement, shall last 4 years from the date of the contract. So, contract of services for an indefinite term, because fixing of a period by the courts may amount to involuntary servitude. Article 1197, the courts shall also fix the duration of the period when it depends upon the will of the debtor. Please read Article 1191 and Article 1687 together with Article 1180. So when does the debtor lose the benefit of period? You have to read Article 1198. Okay? Also, Article 2109. What are the effects of loss of term? So an obligation becomes immediately due and demandable even if the period has not yet expired. An obligation is converted to a pure obligation. So what is the effect of an insolvency of the debtor? So the insolvency need not be judicially declared. The state of financial difficulty is enough. In number 1, factual insolvency is enough. A judicial declaration of insolvency is not required. Thus, again, the different kinds of obligations. Pure and conditional obligations, when the obligation contains no terms or conditions. Conditional obligations, one which is subject to a condition. A condition is every future and uncertain event upon which an obligation or provision is made to depend. The future and uncertain event is the acquisition or resolution of the rights is made to depend by those who execute the juridical act. Classification of conditions. Suspensive, the happening of the former gives rise to an obligation. Resolutory, the happening of the latter extinguishes rights already existing. Past but unknown events. A condition may refer to a past event unknown to the parties. Impossible condition, we have physically impossible and judicially impossible. Physically impossible when it is contrary to law of nature. Judicially impossible when contrary to law, morals, good customs, and public safety. So pure obligations, when it is not subject to a term or period and no condition at all. It is demandable at once, and its immediate demandability gives time for debtor to comply. Period is an event that is future but certain. Example given is passing this class, this obligations and contracts class. Okay? So a past event cannot be a future event and cannot be considered uncertain. So suspensive condition, here the rights are acquired upon the happening of a condition. Article 1181, obligations created upon the happening of a condition. Resolutory, extinguished or loss of existing rights upon the happening of a condition. Thus, a contract may be perfected, but its demandability is suspended. Article 1186, deemed constructively fulfilled, applied only to suspensive, not to resolutory condition. So, Article 1187, effects of conditional obligation to give. 1188, to preserve his interest. So to protect the expectancy of the creditor, so he has to register with the registry of property his expectancy of his right. He needs to have witnesses or a witness. His possession must be in good faith. So he may file a case for injunction if the contract of sale was not consummated, or if the property is not for sale. So, resolutory condition, again, you have to read Article 1190. Here, there are no exceptions, or there is no exception. Walang matitira. In a suspensive condition, upon the happening of the condition, the obligation exists. So, here, existence of obligation is affected. The classification of condition are, the different classifications of condition are potestative, when the fulfillment of the condition depends upon the will of the party to the obligation. Casual, if it depends upon chance or a third person. Or mixed, if it depends partly upon the will of the third party and partly upon chance or of a third person. Again, so mixed depends partly upon the will of the party and partly upon chance or a third person. So, Article 1182, potestative, sole will of the debtor. So, potestative, suspensive is void. Example given is A will give 5% commission to B, but it depends on the will of A, and this is void. All other potestative conditions are valid. So, Article 1183, impossible condition, physical impossibility, and legal impossibility. For Article 873, impossible testamentary conditions, you have to disregard that. Example is Article 727, donation. Suspensive period, prior to the period, there is already an obligation, but it is suspensive by the period. Article 1164, the obligation to deliver arises upon the perfection of the contract, and if subject to suspensive period and not suspensive condition. Resolutory period terminated, but the effects that accrued in the past will remain. Resolutory condition extinguishes as if nothing happens. So, retroactive ang effect nito sa obligation. Effects of fortuitous event in period or term. The contract shall be deemed suspended, but the fortuitous event shall not stop the running of the term or period agreed upon. So, the presumption is that if the period is designated, the benefit is for both the creditor and the debtor. The exception is where the tenor of the same or other circumstances, it should appear that the period has been established in favor of one or of the other. So for Article 1197, there are 3 reasons why the court will fix the period. Number 1 is if the obligation does not fix a period, but from its nature and circumstances, it can be inferred that the period was intended by the parties. Number 2, in the duration of the time if the duration of the time depends upon the will of the debtor. And lastly, if the debtor binds himself to pay when his means permit him to do so. Again, you have to memorize Article 1198. This is when the debtor shall lose every right to make use of the period. So after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or a security for the debt. Or if he does not furnish to the creditor the guarantees or securities which he has promised, or by his own acts he has impaired said guarantees or securities after their establishment. And when through a fortuitous event, they disappear unless he immediately gives new ones equally satisfactorily. So, and when the debtor violates any undertaking in consideration of which the creditor agreed to the period and the debtor attempts to abscond.